You're in the military and you've been charged with sexual assault, or you've been told that you're under investigation. What happens next? Now, what's happened likely is that either a friend, a coworker, or a military law enforcement agent has told you that you're under investigation or that you've been charged. Now, if it's someone from military law enforcement, if you're Army, it would have been Army CID. If you were in the Navy or Marine Corps, it would have been NCIS. In the Air Force, it would have been OSI. And in the Coast Guard, it would have been CJIS. If it was anyone else that says they were investigating you, whether it was the command, whether it was Marine Corps CID, Army MPs, or Air Force security forces, it's not a sexual assault investigation. It's something else. Those are the only agencies that investigate sexual assault in the military. Now, if you haven't been called in to see the agency, this is what will happen. If you've already been called in, this is what did happen. You were read some sort of statement or shown something that listed some sort of charge, and it probably said something about Article 120 or Article 120 Bravo or Article 120 Charlie. And then there's a good chance that the agent told you, you're not actually being charged with anything. You're just suspected. That's a trick. Here's a secret about the military. No military law enforcement agency, whether it's CID, NCIS, OSI, or CJIS, has any ability to decide whether you go to a court-martial, and they have no ability or power to charge you. They don't. All they can do, they don't even make recommendations. All they can do is investigate. So when they show you a sheet and they tell you to cross out charged and write suspected, which is what they often do, any of that, it's just a trick to try and get you to talk to them. They're all the same. All that it is that yes, they are really trying to get you to say something that they can use against you, because that's what they consider to be the key part of the investigation. Now, if you haven't already gone to see them, great, because the first thing you need to do when you do get called in is to say, I want a lawyer, I want to remain silent. If you've already gone to see them, well, hopefully you asked to remain silent, but if you didn't, well, then we'll have to deal with that at a different time. Now, whether you're going to see them or if you already saw them, they probably took your fingerprints and DNA. That's normal, that's part of the process. They probably also told you that they couldn't tell you the specifics of what you were under investigation for. The reality is that before they try and talk to you, they've already talked to your accuser and gotten a statement. They've probably talked to other potential witnesses. They probably already tried to see some evidence. And they do all of that before trying to talk to you. They're also allowed to lie to you and tell you they have evidence they don't actually have, which is something that can lead to false confessions. But you're probably wondering, well, I want to see the statement against me. Aren't I entitled to actually see the evidence against you? And the answer is you are if you're actually court-martialed, but not while you're under investigation. They will never give you the statement of your accuser unless the case actually gets charged. So you're going to be in a holding pattern for a while, unfortunately. Like I said, they'll talk to other witnesses. If there's DNA evidence in the case, that gets sent to a lab, and that takes a few months to resolve and come back. If they seized a phone or they seized computers, that also goes to a lab and can take a few months for them to come back. But eventually, after a few months of investigation, usually somewhere between 4 to 9 months, but sometimes longer, the entire investigation gets wrapped up into what's called an ROI, or report of investigation. And that ROI gets sent to the prosecutors, the lawyers at the Office of Special Trial Counsel. Those lawyers are the ones who will determine whether or not to charge you and actually bring you to trial. When that happens, if you're actually charged, you'll be handed a sheet of paper called a preferral charges. It'll be given to you either by your command, by a paralegal, or by a lawyer. And when you have that sheet of paper, then they have to provide at least some of the evidence against you to your lawyers. but only then. And that's when it's possible to actually go to war in your defense. Now, before that, you've probably gone to see, if you're in the Army, you went to see Trial Defense Services or TDS. If you were in the Marines or the Navy, you probably went to the DSO or Defense Service Office. If you're in the Air Force, you went to see the ADC. Coast Guard, you also went to the DSO. And the ADC and the Air Force being the Area Defense Council. And whichever you went to see, they probably told you that there's not much they can do for you until the case is actually charged, but they would have told you to remain silent. If you hire a civilian defense counsel, such as us, there are a few additional things we can do. We can investigate your accuser. We can talk to witnesses. We can start developing a case strategy in case the case gets charged. But yes, there are still limits because, again, we won't be provided that investigation either, that ROI, until the case is charged. And sometimes we can even talk to the prosecutors and persuade them not to charge you. It depends a bit upon the type of case, depends upon the evidence, and it depends upon the prosecutors, but it's possible. But at the end of the day, your real rights begin when the case is actually charged. Now, you probably have a lot more questions. You can reach us directly at 202-931-8509, and we'll be happy to answer them. That's 202-931-8509. This is Nathan Freeberg with Cave and Freeberg. Thanks.